Hello and welcome to UGC EPG Pathshala project. I am Neeraj Tiwari, Assistant Professor Law, National Law University, Delhi, and I will be presenting module on pre-trial process, procuring attendance of person and production of documents. Let us begin with learning objectives. The object of this module is to make the learners understand the need for securing appearance of persons and production of documents in a criminal trial. Secondly, to make the learners understand various processes to compel the presence of the accused, to acquaint the learners with the process relating to production of documents and other things, and lastly, to make the learners understand the circumstances in which search can be made with or without warrant. Now, the general rule in criminal trial is that the court should not proceed ex parte against the accused. It is also known as one of the foremost requirements of fair trial principle that the trial must proceed in the presence of the accused. The presence of the accused during trial is not a mere formality, but it gives an opportunity to the accused to understand the prosecution case, witnesses and evidence against him. This gives him a fair chance to prepare his defense as well. While taking measures for ensuring presence of the accused in a criminal trial, his personal liberty should not be lost sight of. The detention of the accused prior to trial will also cause unnecessary obstruction in the preparation of his defense. Therefore, if his presence can be reasonably ensured, he should not be deprived of his personal liberty. Similarly, police and court may also require documents and other things for the purposes of swift investigation and inquiry and trial. Such documents may be required to establish the truth in a given case. It may also be helpful to the accused to prove his innocence, or may also be required by the prosecution to prove his guilt. Therefore, procurement of such documents and other relevant things may be vital from the point of view of the end result in a criminal case, that is justice. The primary aim of this module is to explain various processes or methods envisaged under the code for securing attendance of the person and production of documents required for conducting investigation, inquiry and trial. Now, let us start first to discuss various methods prescribed under the code of criminal procedure for securing the attendance of a person before the court. The code prescribes for three processes or methods to secure the attendance of an accused person or other relevant persons like witnesses before it. The first and foremost is by issuing summons. Secondly, by issuing warrant for arrest. Thirdly, proclamation and attachment of property. And lastly, there is another method provided under the code under section 88, which deals with a situation where the accused person happens to be in the court. He may be required to execute bond for security for attendance before the court. Now, let us begin with summons. There are certain rules regarding summons provided under section 204 of the code. It provides that in all summons cases, a summons should issue in the first instance. In a warrant case, a warrant should ordinarily issue, but even in such cases, the magistrate has the power or discretion to issue summons if he thinks fit. The court may, in lieu of or in addition to issuing of summons, may issue a warrant where there are reason to believe that the person will not obey the summons, or where he does not attend the court without any reasonable excuse after service of summons as per section 87 of the code. Now, forms of summons. Now, the formal requirement of summons is given under section 61 of the code, which speaks that a summons must be in writing, must be issued in duplicate, must be signed by the presiding officer of the court and must bear seal of the court as well. Other than these requirements, there are certain other requirements also which a summons must satisfy. Firstly, it must clearly mention the title of the court, place, day and time when the attendance of the person summoned is required. It must also state that such person not to leave the court or must not depart from the court without leave of the court and without ascertaining the date to which the case may be adjourned. Now, coming to the persons authorized for the service of summons, in this regard section 62 of the code is relevant, which provides three types of persons who are authorized for service of summons. They are any police officer, any officer of the court issuing it, or any other public servant. So, any of these persons may be authorized for service of summons by the court. Now, summons how served? Modes of service of summons depend on whether it is to be served on a person or an entity. The code prescribes different modes for service of summons depending on the person or the entity on whom it is to be served. To begin with, the first and foremost method of service of summons is personal service. It is the primary mode of service of summons, which means delivering or tendering one of the duplicates of the summons to the persons to be served. Service on adult male family member. If the person to be served cannot be found by the exercise of due diligence, service may be effected by leaving one of the duplicates for him on some adult male member of the family, but not on servant. If required, the serving officer may take the signature of such member on the back of the other duplicate. Substituted mode of service. In case even after exercising due diligence, the summons cannot be served in any of the above modes, it shall be served by affixing one of the duplicates to some conspicuous place or part of the house in which the person summoned ordinarily resides. The court, after making such inquiries as it thinks fit, may either declare that the summons has been duly served or order fresh service. Service on government employee. The summons is to be forwarded to the head of the office in which the said person is employed, and the letter will cause it to be served as per section 62 of the code. Service on corporation. It is to be personally served on the secretary, local manager, or other principal officer of the corporation, or it may be sent by registered post addressed to the chief officer of the corporation. Service on witnesses. The court issuing a summon to a witness may, in addition to and simultaneously with the issue of such summons, direct a copy of the summons to be served by registered post addressed to the witness. Service outside the local jurisdiction of the court issuing it. The court shall send the summons for service to a magistrate within whose local jurisdiction the service is to be made. So, we have seen that the methods for service of summons differs from person to person, and even in case of entity, it is also prescribed different modes for service of summons. Now, let us see some instances of invalid service of summons which has been declared through various case laws. Now, the first and foremost example of invalid service of summons is the case where the service of summons on an accused person is made through registered post. The court is of the opinion that such a service of summons through registered post to an accused person is not valid. Secondly, service of summons by serving it on the pleader of the accused is also held by the court as invalid service of summons. Thirdly, in the absence of service, knowledge from other sources are not sufficient. So, where the accused comes to know that summons has been issued against him from other sources, will not be enough for him to be prosecuted or to be proceeded against him. And lastly, publication in the official gazette not a valid mode of service of summons as well. Now, let us come to the second method which is prescribed under the code for securing the attendance of a person before the court. Now, we have seen that summons is a milder form of or milder method to secure the attendance of a person. Now, warrant of arrest is second method which can be used by the court for seeking attendance of the person before it. Warrant of arrest, it is a written order issued and signed by a magistrate addressed to a certain person to arrest the accused, to take him into custody and bring him before the court issuing the warrant. So, it is very clear by the definition of warrant that it is a written order issued and signed by the magistrate addressed to a certain person for the purposes of arresting the accused, to take him into custody, to bring him before the court issuing it. Now, the formal requirements of a warrant of arrest is as follows. First and foremost, it is issued by a court, it is issued in writing, it bears name and designation of the person who is to execute it, gives full name and description of the person to be arrested, state the offence charged, signed by the presiding officer, and it bears the seal of the court as well. Now, general rules relating to warrant of arrest. First and foremost, a warrant of arrest should not be issued where summons would be sufficient to secure the ends of justice. A warrant, once issued, remain in force until it is cancelled or executed. A warrant of arrest may be executed at any place in India. It is not restricted to the local limits of the court or the magistrate issuing such warrant. And lastly, a warrant may be issued for the arrest of a person who fails to appear in court after having executed a bond in that behalf as per section 88 of the code. Now, modes of execution of a warrant of arrest. The general rule is that a warrant of arrest should be directed to a police officer or officers for execution, but there are certain exceptions to this rule as well. Where the arrest is immediately necessary and no police officer is available for execution of the warrant, a warrant of arrest may be directed to a person other than a police officer. Now, the instances in which a court may direct any other person other than a police officer to execute such a warrant may be as follows: where it is directed to arrest any escaped convict or a proclaimed offender, or any person accused of a non-bailable offence who is evading arrest. So, in these cases, a court may issue direction to execute a warrant of arrest by any other person other than police officer as well. Now, execution outside the local jurisdiction of the court issuing it. So, where a warrant of arrest is to be executed outside the local jurisdiction of a court issuing it, such court may forward the warrant of arrest by post or otherwise. It may be sent to the executive magistrate or district superintendent of police or commissioner of police within the local limits of whose jurisdiction it is to be executed. Now, where it is directed to a police officer to execute outside the local jurisdiction of the court issuing it, in such a scenario, he is required to take the same for endorsement either to an executive magistrate or to a police officer not below the rank of an officer in charge of a police station within the local limits of whose jurisdiction it is to be executed. So, in these two instances where the execution of a warrant of arrest is to be made outside the local jurisdiction of the court issuing it, these are the procedure to be followed by the police. Now, obligation upon the person executing a warrant. Now, the person is obliged to notify the substance of the warrant to the person to be arrested and even to show the warrant if required or asked by the person to be arrested. Non-compliance of these requirements will make the arrest illegal. The person executing a warrant of arrest is under an obligation to bring the person arrested before the court without unnecessary delay. Now, let us see two different kinds of warrants which can be issued by the court, one named as bailable warrants, other named as non-bailable warrants. Though these terminologies are not found anywhere in the code, but the term bailable warrant may be derived from section 71 of the code. Now, section 71 of the code confers a discretion upon the magistrate issuing a warrant of arrest to make it bailable. Where the arrested person executes a bond with sufficient sureties for his attendance before the court at a specified date and time, the officer to whom the warrant is directed shall take such security and release the person from custody. So, that is how under section 71 of the code a bailable warrant may be issued by the magistrate. Now, let us discuss the non-bailable warrant. See, again the terminology is not defined or not found anywhere in the code, but merely because the warrant uses the expression like non-bailable by itself cannot render the warrant bad in law. Under section 70, a judicial magistrate can convert warrant of arrest into a bailable warrant he may also issue orders with regard to issuance of a non-bailable warrants. With regard to non-bailable warrants and its issuance, the Supreme Court time and again has given direction to the magistracy that it should not be issued in cases where summons or bailable warrants can fulfill the purpose. Now, in the case of Raghuvansh Divanchand Bhasin versus State of Maharashtra, a 2012 Supreme Court decision, it was held that warrant of arrest cannot be issued mechanically or arbitrarily, but only after recording reasons that in the facts and circumstances of the case it is warranted. The courts have to be extra cautious and careful while directing issue of non-bailable warrant, else a wrongful detention would amount to denial of a constitutional mandate envisaged under Article 21 of the Constitution of India. So, in this case the Supreme Court has made it very clear that in all cases the magistrate must satisfy himself that there are enough reasons for issuing non-bailable warrants. Now, in case of Inder Mohan Goswami versus State of Uttaranchal, a case of 2007 Supreme Court, it was held that non-bailable warrant should be issued to bring a person to court when summons or bailable warrants would be unlikely to have the desired result. The court further explained the circumstances in which a non-bailable warrant may be issued. These are where it is reasonable to believe that the person will not voluntarily appear in the court, or the police authorities are unable to find the person to serve him with the summon, or it is considered that the person could harm someone if not placed into custody immediately. Similarly, in the case of State of UP versus Pusu, it was held by the Supreme Court that before exercising its power, the court should consider factors like nature and seriousness of the offence involved, the past conduct of the accused, his age, and the possibility of his absconding before issuing such non-bailable warrants. In a most recent judgment of 2014, in the case of Vikas versus State of Rajasthan, the Supreme Court reiterated the principle of personal liberty in cases of issuance of non-bailable warrants. The court has stated that the court should properly balance both personal liberty and societal interest before issuing warrants. There cannot be any straitjacket formula for issuance of warrants, but as a general rule, unless an accused is likely to tamper or destroy the evidence or is likely to evade the process of law, issuance of non-bailable warrant should be avoided. The court is in all circumstances, in complaint cases, at the first instance should first prefer issuance of summons or bailable warrants, failing which a non-bailable warrant should be issued. The Supreme Court has modified the order passed by the trial court in this case and directed that summons be issued against the appellant for his appearance. So, we have seen that even in cases of warrant, which can be a bailable one or non-bailable one, it must be issued only when there are circumstances to believe that the person against whom it is issued will not obey the summons. And in cases of non-bailable warrants, it must be issued only in cases where there are chances that the accused person may evade arrest or he may destroy the evidence in any given case. Now, let us discuss the third method to secure the attendance of a person before the court, and that is proclamation and attachment of property. Now, where summons is issued and there is reason to believe that the accused has absconded or will not obey the summons or fails to appear before the court, a warrant of arrest can be issued. And where there are reasons to believe that the accused person is absconding or concealing himself to avoid the execution of warrant, proclamation and attachment of property proceeding can be initiated. The object of a proclamation and attachment of property is to put considerable pressure on the accused person so as to impel him to appear before the court in order to avoid deprivation of his property. But before issuing a proclamation, the court must satisfy itself that a warrant of arrest had already been issued and the accused is either absconding, concealing or evading the execution of warrant of arrest. In such a scenario, the court may publish a written proclamation requiring the accused person to appear at a specified time and date, and place, and not less than 30 days from the date of publishing such proclamation. The court issuing such proclamation may at any time thereafter order the attachment of any property, movable or immovable or both, belonging to the proclaimed person. If the proclaimed person appears within the time specified in the proclamation, the court shall issue or make an order releasing the property from the attachment. Now, modes of publication given as in section 82 subclause 2 are as follows. First, it shall be publicly read in some conspicuous place of the town or village in which such person ordinarily resides. Secondly, shall be affixed to some conspicuous part of the house in which such person ordinarily resides, or to some conspicuous place of such town or village. And thirdly, a copy of proclamation shall be affixed to some conspicuous part of the court issuing it as well. Now, additional mode of publication may be in any daily newspaper circulating in the place in which such person ordinarily resides. Now, simultaneous order of attachment and issue of proclamation. The general rule is an order of attachment can be made only after the issuance of proclamation, and where the person do not appear within the time specified, an order for attachment of his property can be made, but there are certain exceptions to this as well. Now, these exceptions are where the proclaimed person is about to dispose of the whole or any part of his property, or where the proclaimed person is about to remove the whole or any part of his property from the local jurisdiction of the court. An order of attachment can be made simultaneously with the issue of the proclamation. So, in these circumstances, an issue of proclamation and attachment of property simultaneously is justified. Now, let us see the procedure regarding attachment of property. As we have seen that the purpose of attachment of property of the absconder is not to punish him, but to procure his presence. If the proclaimed person does not appear within the time specified in the proclamation, the property under the attachment shall be at the disposal of the state government. Now, the state government may sell the property in following situation, where the time period of 6 months from the date of the attachment is expired, and where any claim preferred or objection made under section 84 is disposed of. In these two circumstances, the state government may dispose of the property or may sell the property of the absconder. Provided further that where the property is subject to speedy and natural decay, or the sale would be for the benefit of the absconder, the court may cause it to be sold whenever it thinks fit. So, in these circumstances, the property may be sold at the instance of the court. Now, let us discuss the second head of this module, which deals with process to compel the production of documents and other relevant things. Now, the court prescribes for two methods for production of documents and other relevant things before the court. First is given in under section 91, that is summons to produce the documents and other things, and second, that is section 93, which talks about search warrants. Let us begin with the production of documents and other things on summons. Now, process to compel production of documents or other things. Section 91 confers a general power on court and police to issue summons or order for production of documents or other things. Such court or officer must be of the opinion that prima facie the production of such documents or things is necessary for the purpose of conducting investigation, inquiry or trial. Such summons or order may be issued at any stage of the investigation, inquiry or trial. Intentional omission to produce a document or thing in compliance with the summons or order issued under this section is punishable under section 175 of the Indian Penal Code. Now, who can invoke this power of the court or police officer? Such power may be invoked at the instance of any party to the proceeding, including the prosecution or complainant or accused as well. Here, one thing is to be noted, that the expression person in section 91 does not include an accused person. Therefore, an accused person cannot be asked to produce a document or other relevant thing which is incriminating in nature or which may prove against him. In this regard, it is to be seen that he is given protection of Article 20 sub clause 3 of the Constitution. Now, search warrants, as mentioned before, search warrants are mentioned in section 93 of the code. Search warrant is a warrant issued by a court for the search of a place and to be executed in the same manner as a warrant for arrest of a person is made. It is more efficacious method for the production of document or thing. It is more drastic step and involves serious invasion of the rights and privacy of an individual. It is addressed to a police officer for execution. Now, the circumstances in which search warrant can be issued: where the court has reason to believe that summons for production will not be obeyed, and where it is not known whether the document or thing is in the possession of any person or court, or where a general search or inspection is considered necessary for purpose of any trial or inquiry or other proceeding of the court, a search warrant under section 93 can be made. Now, there are certain other situations as well prescribed in section 93 in which a search warrant can also be issued. These are search of a place suspected to contain stolen property, forged documents, etc., or search of a place suspected to contain any book, newspaper or documents which the state government has declared to be forfeited, and lastly, search for the person who is wrongfully confined. So, in all these three categories of situations, a search warrant can be issued under section 93 as well. Search of a place. Section 100 of the code provides for search of a place, and it says that any person residing in or being charged of such close place shall, on production of the warrant, allow free entry and afford all reasonable means for smooth search of the place. If there is any reasonable suspicion that any person is concealing on his person any article or thing for which the search of a place is to be made, the person may be searched. But if the person is to be searched is a woman, then the search shall be made by another woman with strict regard to her decency. There are certain safeguards provided in section 100 against this search of places. First and foremost is the search should be made in presence of two or more independent and respectable witnesses. A list of things seized in course of the search should be prepared and signature of the witnesses should be obtained on it. The occupant of the place searched or his representative should be permitted to attend the search, and a copy of the search list should be delivered to him. And these safeguards are made applicable in all cases whether the search is with or without warrant. So, therefore, section 100 does not provide for a blanket search, and it has certain safeguards provided to the person whose premises or whose house or any other building is to be searched in that regard. Now, let us discuss the circumstances in which search of a place can be made without warrant by a magistrate or a police officer. Now, section 103 empowers a magistrate to direct a search to be made in his presence. This can be of any place for the search of which he is competent to issue a search warrant. Similarly, a police officer during any investigation in exceptional circumstances may carry out search without warrant by virtue of section 165 of the code. Section 166 enables a police officer to effectuate search of a place located beyond the limits of his own police station if the exigencies of the situation require. Where a police officer in charge of a police station has reason to believe that weight, measures and instruments for weighing which are false are used or kept in any place, he can inspect and search that place and seize such things as per section 153 of the code. So, these are the cases in which a search can be made without warrant by a magistrate and police. As it can be seen that the police is conferred with power to make such search without warrant, certain safeguards are also provided to protect the individual from arbitrary search or such abuse of powers on the part of the police officers. These safeguards are: section 165 does not permit a general search, and it authorizes police officer the power to search for particular things or documents necessary for the purpose of investigation. Therefore, under section 165, a general search cannot be conducted, and the search must be pertaining to certain specific documents or other necessary things which are required for the purposes of investigation. Secondly, the police officer must have reasonable ground for believing that the thing for which search is to be made for the purpose of the investigation may be found in the place within the limits of his police station, and such thing in his opinion cannot otherwise be obtained without undue delay. The police officer, before proceeding to search a place, must record the grounds of his belief as to the necessity of such search, and must also specify the things for which the search is to be conducted. The non-recording of reasons for search would make the search illegal, and at the same time copies of record relating to searches made by the police officer shall be sent forthwith to the nearest magistrate. Therefore, it can be seen that these safeguards are well enough to protect the individuals from any arbitrary search or abuse of power on the part of the police officers, and at the same time the police officer is put under a check by the magistrate, because he is required to send the copies of the record forthwith to the magistrate. Seizure. Section 102 of the code confers power on a police officer to seize certain property. It has been held in the case of MT and Rika Lexi versus Durama in the year 2012 by the Supreme Court that power under section 102 can be exercised if such property is alleged to be stolen or is suspected to be stolen, or the object of the crime under investigation, or has direct link with the commission of offence under investigation. Where a search warrant is issued for the search of any particular thing, the person making the search has been empowered to seize such things if recovered during search. At the same time, every police officer shall report the seizure to the magistrate, and in case the property cannot be carried to the court, to give it to a person executing bond for its production before the court. So, it can be seen from the discussion so far that the code prescribes for different methods for securing the attendance of persons as well as procuring the documents and other relevant things required for the purposes of investigation, inquiry and trial. As far as securing the attendance of the accused is concerned, we have seen that the methods like summons, warrant, proclamation and attachment of property are the measures adopted by the court to secure the attendance of a person before it. Summons, being the milder method, should be used at the first instance, and in case it is not obeyed by the accused, the court may resort to other methods. But in no case the proclamation and attachment of property proceeding shall begin before issuance of warrant. Issuance of warrant is a condition precedent for invoking the proceeding of proclamation and attachment of property. We have also discussed the non-bailable warrants must not be issued at first instance. It has been observed by courts through various cases that such issuance of non-bailable warrant is violative of Article 21 of the Constitution. Similarly, in case of production of documents and other things, the code prescribes for summons and search as effective methods to procure the same. In this regard, both police and magistrate are given power under the code. Therefore, we have seen that on a combined reading of these provisions will take us through the processes at pre-trial stage which can be invoked by the police as well as by the magistrate to procure the attendance of a person before it, or production of documents or other relevant things which are necessary for the inquiry, investigation and trial. Thank you.